Welcome. Thank you.
Good afternoon.
Good afternoon,
David Majanja, Judge of the High Court and Commissioner. You're welcome.
Thank you.
Thank you, Honorable Commissioners, for that introduction. Before we delve into the interview, I wish to disclose that Honorable Minde worked with me in Nakuru, so I know her in that capacity. Commissioners will be engaging you with questions on your application for the position of a judge that you have made here. But before we go into the questions, you can confirm to us your county and your ethnicity.
Thank you, Honorable Chair. My county is Kisumu.
Kisumu.
My ethnicity is Luo.
Very well. The first set of questions will be guided by Honorable Macharia.
Thank you.
Okay, thank you. I have two questions. I'm looking at your CV, which is quite comprehensive, and you've served in many areas as a chief magistrate, but more importantly also as a commissioner of this commission. So, which brings me to the question that could you tell us two things? One factor that you take into consideration if you became a judge that would make you a very impactful judge. And when I'm asking this question, you know, there are many judges that become appointed, you never hear of them until later on when they retire. Now, what is it that you think you do, just that one thing, that will make you be very impactful as a judge? Then as you're answering that, what pitfall again you would avoid so that you don't become one of those judges who get there, then they run afoul, you know, with either the Judicial Code of Conduct or the laws of the country, or, you know, they get again into trouble. So you answer from both perspectives.
Thank you very much. Thank you, Honorable Chair. Thank you, Commissioner. I don't know whether I should introduce myself or I go straight to the question.
You can maybe briefly, you can introduce yourself briefly.
Thank you.
Already done, then you go straight to the question.
Thank you. Thank you very much. As indicated, my name is Emilio Minde Onyando. I am currently a chief magistrate serving as Kiambu Law Court. As you can see from my CV, I graduated from the University of Nairobi with a Bachelor of Laws in 1989, with a diploma from School of Law in 1990. I did a short stint at the Office of the Attorney General, joined the Judiciary 2nd May 1991, and I have diligently served uninterrupted until this moment in time. I've headed various courts, notably Makadara, Machakos, Kibera, Kikuyu. I've been Deputy Registrar, Family Division, and I've worn many hats apart from being just a magistrate sitting in court hearing and determining cases. I have sat in this commission representing the interests of the magistrates, registrars and Kadhi for 2 successive terms. I have been very active in the welfare associations within the judiciary, Kenya Magistrates and Judges, Kenya Women Judges, and even in the East African Magistrates and Judges Association, which is an affiliate. And in all those associations, I've always served as secretary. And so, of course, I've developed, developed many skills in these capacities that I've had, which I am sure will be useful to the institution: leadership, organizational, communication, team building, court and case management, and mentorship skills. So, coming to the question, but I thank you also for giving me this opportunity to come and defend my application. Now, coming to the question, if we look at Article 165 on the mandate of the High Court, and we look at the constitution that we currently have, it is a very, very transformative constitution. It is a constitution that has put people at the center. The Bill of Rights is very expansive. The High Court is the first port of call in the interpretation and application of the Constitution. Now, because we have this very new, transformative, people-centered Constitution, and as a High Court judge, one of my key mandates is to interpret and apply it. The thing that I will be remembered for is that I will be a judge who will not shy away, but will interpret this Constitution in ensuring that the basic fundamental rights and freedoms of the citizenry is not only guaranteed, but it is protected to the extent that we can then say that we are a constitutional democracy hinged on the rule of law, respects the fundamental freedoms and rights of individuals, promotes good governance, just in ensuring that the rights of people are protected. I will not shy away from disciplining government when there is need to do so in matters judicial review, in matters declaring unconstitutional or invalid acts of parliament that go against the fundamentals of the Constitution. And so I would say that I would be a judge who is alive to the fact that the people have placed upon me a trust to ensure that everything that I do in their name is done to ensure that they feel that they matter within the Republic. The pitfall then would be to ensure that I would need people to trust my decisions. I would need a situation where people say, if your matter is before midday, you need not worry yourself, because whatever it is that you're deserving of, you will get. And of course, then I will ensure that not only will I apply the Article 10, leadership and governance principles, uphold integrity and the independence of my decisions at all times in applying and interpreting the Constitution and any other law. That is how I'd want to be remembered, as a judge who was faithful to the dictates of the Constitution, even when it was not convenient to do so, even when, let me say, it was dangerous to do so. Thank you very much.
You, in answering the questions, you preempted some of the questions I'm going to ask. So I'm satisfied. All right.
Thank you.
Thank you, my lady. Once again, good afternoon.
Good afternoon, Commissioner.
So I have a quick question for you. There is a principle of res judicata. What do you understand about that principle?
Now, the principle of res judicata is a principle of law that is meant to ensure that disputes come to an end. So therefore, it applies where, if a dispute has been heard by a court of competent jurisdiction, and the same parties that would want to bring another matter appeared before this court of competent jurisdiction, they litigated over the same subject matter, then they are stopped by the principle of res judicata from again opening the same litigation before another court, so that as much as possible disputes come to an end once a court has rendered itself on the issues before it.
Okay. That is correct. Now, let's say you are successful in your bid to become a judge, and you find yourself in the family division, and an appeal has been brought before you, where the respondent is complaining that, or rather the ground of appeal is that the matter that was heard in the magistrate's court, in the family court in the magistrate's court, had been heard before. That is to say, between the respondent and the petitioner, there had been a divorce petition heard earlier, say 5 years ago, and it was dismissed. Subsequently, after 5 years, the petitioner has brought another divorce petition, and the respondent raised res judicata, but the magistrate allowed the divorce. If you're not clear about the facts, let me repeat them. Should I repeat the facts?
No. I think I'm clear.
You're clear. So what would your decision be, if that is the sole ground of appeal? What would your decision be and why? And feel free to cite any case law if you have any.
The issue on the 5 years, what happened during?
The respondent who has appealed to your court is saying, before this decision I'm appealing now, there had been a divorce petition between me and my wife, for example. And the divorce petition was dismissed 5 years ago. So they had a divorce petition before the magistrate's court. 5 years ago, it was dismissed. Now, 5 years later, the wife filed another divorce petition. And the respondent raised res judicata, but the magistrate allowed the divorce. So the respondent is before you on appeal and is saying the magistrate should not have listened to this case because it's now res judicata.
Now, if they were the same parties, they are the same couple, they are seeking divorce.
Yes.
The magistrate's court had jurisdiction, had the matter substantively, and you said dismissed or allowed?
The first time dismissed, 5 years later another petition is brought.
Before the same magistrate?
Before a magistrate's court.
No, it ought not to have been heard. I think the principle of res judicata ought to have applied, and so therefore the other magistrate's court ought not have had the divorce petition if the parties were the same, unless, and the grounds for divorce were the same, and the court had jurisdiction.
Yes, that's where I wanted to zero in. So this is a divorce that was had 5 years before and dismissed. 5 years later, a divorce petition has been brought. What is the consideration you would have in making a decision in that scenario?
In the High Court?
Yes, in the High Court. You're now listening to the appeal.
Commissioner, I'm not very clear on that one, I'm sorry.
Okay, maybe just by way of guidance, would the grounds still be the same grounds that were entertained 5 years ago? If the divorce is, a subsequent petition is brought 5 years later?
The grounds, okay. I think you'd go by the grounds for divorce in the Marriage Act?
Yes.
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 In the petition. So the grounds may not necessarily be the same, but they could be expanded. They are more expanded under the Act.
Yes.
Yes. Whereas, if I'm not wrong, I think the grounds for divorce in the Magistrates Courts Act, a magistrate's court, are set out in the Act.
Yes.
Yes, in the Magistrates Courts Act. Yes.
So what will be the difference in the subsequent petition if you look at it?
Now, if I look at the Marriage Act, the difference would be, number one, did the officiating pastor have the capacity? Did the parties have capacity, mental or otherwise? Were all the parties present at the, did they attend to the marriage?
Those are the grounds that would make the marriage valid.
If it is not consumed, or if this marriage has not been consummated, since the marriage was entered into, then if during the subsistence of the marriage one of the parties is mentally unstable.
Yeah, those are the issues that will invalidate the marriage, isn't it?
Yes.
So what I'm asking is, if, for example, 5 years ago I came and failed to prove cruelty, is it possible for me to come again 5 years later on the ground of cruelty? Now I have broken it down. Is it possible for me to come and say, this person, I mean, I want to divorce him on the ground of cruelty?
I don't think so. Let me just say I'm not very clear.
Oh, okay, thank you.
Thank you.
Thank you, my lady.
Thank you. When you are answering Commissioner Macharia, you mentioned the power given by the Constitution to the High Court to interpret statutes, the constitutionality or lack of it. The courts have been criticized of late for declaring statutes unconstitutional without any basis. Are you aware of that criticism, and in which area?
I think the greatest criticism, Honorable Chair, is particularly the one on the unconstitutionality of the sentence of life imprisonment in sexual offenses. Because if a child is between 8 and 12 years and that child is defiled, then the perpetrator is to be imprisoned. It's the minimum sentence is life imprisonment. The courts have found that this is inhuman and degrading punishment because of the indefinite nature of the life sentence. And so I know of late the Court of Appeal has set the life sentence at 30 years. I am also aware that there is a situation where the High Court reduced a life sentence to 15 years. And so there's a lot of hue and cry, particularly from organizations who deal with the rights and welfare of the child, that those sentences do not consider the circumstances of the victims. So that is one that is ongoing.
And what is your own view on that inconsistency in sentencing, especially where there are the minimum provisions in the law?
My view, Honorable Chair, would be that we need to set a definite sentence. Even if we agree that the indeterminate nature of the life sentence is such that it is inhuman, degrading and inhuman, we need to cap it at something. Because I would agree with the persons who are the hue and cry. Because particularly one, the offender was 6 years old. The Court of Appeal one, the offender was 8 years old. Now, if you sit in a court hearing and determining cases of defilements, I'm not saying that we must empathize with the victim because we are supposed to be very dispassionate, but we cannot close our eyes sometimes to the brutality that is meted out on these young people and left with scars for life. And so I think we need directions such that we have maybe not less than and not more than. But then again, I was asking myself when I was looking at it, the age of criminal liability is 12. And then we say a life sentence can only be up to 30 years. Now, if you have to sentence a child, or let's say an offender, or let's take 18 years. Now, if he was 18 when he committed the offense and you had 30 years, At 58 years, he's out. Now, in my view, it is possible that he could commit even more horrendous offenses along this line. So I'm thinking a 58-year-old, 60-year-old is still very capable, because we have had sexual offenses where the perpetrators are even 65, 70, and
I think your views are valid, because that has gone on to even probation period for the perpetrators of defilement.
Yes.
Yeah, so your concerns are also valid. So to the next segment of that question, what are the guiding principles when you have to find a statute is unconstitutional? At least 4 of them that would guide you. You explained it very well when you asked.
Yes. Now, of course, the presumption is that every statute, whatever goes by the Constitution.
Yes. The presumption of constitutionality is one, too.
Is one. Then you must ask yourself, what is the purpose for the enactment of the statute?
Yes, the purpose, number 2.
Yes. And then, what is the mischief that the statute was meant to cure? And then, of course, it must conform, everything about the purpose and the objects of this statute must conform to the provisions on the national principles of governance and the Bill of Rights. It must not then infringe on the rights and fundamental freedoms of any individual.
I'm actually happy with that. In Kiambu, what are the most prevalent challenges in your courts?
In the day-to-day administration of the court or hearing and determining cases?
Yes, the cases that bother you there.
Yes, in Kiambu, we have a lot of defilements, robberies, and obtaining by false pretenses.
It's criminal offenses that are most prevalent.
Yes. Now, one of the challenges is the documentary aspect of it when it comes to obtaining. The other issue, of course, we have a lot of these wash-wash cases, let me call them wash-wash, where the people who have been obtained from are foreigners, and so getting them to court to testify is almost impossible.
And what are you doing as a court to reduce that kind of a problem?
Now, what we do is we give the prosecution, much as we appreciate that the complainant also has a right to be heard under Article 50, but we cannot extend cases forever. And so we give the prosecution an opportunity to proceed with the case as far as is reasonably practicable. But remember, the accused is also entitled to an expeditious hearing. And so, of course, when it becomes untenable to go on mentioning cases because the witness is a Chinese, Turkey, whatever, then we offer the solution of getting the witness testify virtually, if it's not possible to avail him physically in court. So we have used that also, but more often than not, when they don't come, then I usually encourage the prosecution, instead of terminating the case, withdraw it under 87A. When you put your house in order, you can bring back the case.
Thank you.
So that is one thing we do. We have cases that are very clear. The moment you hear the first witness, the accused already knows he has no case. And so as much as possible, they try to really convolute the issues. This drags the cases because you find yourself giving one making one ruling after another on whether whatever he's asking for is entitled to or not. What we have done, when we do our mentions, we use the virtual platform as much as possible, so that people don't have to come to court unnecessarily just for a mention. Now, once we confirm hearings, in criminal trials where there are many documents, we'd rather they come to court so that the sharing of the documents is easy. In civil cases, say confirmation of grants, applications, those ones we do virtually as much as possible. Where we have road traffic accident cases, where the witnesses are 2 or 3, we do them virtually so that we expedite the process.
I'm happy with that. Justice Majaj.
Good afternoon.
Good afternoon, Judge.
We were with you here in the Commission for the last 5 years.
Yes.
So I'll just ask you one question.
Thank you.
I've looked at your sample writings, and there's one case that has intrigued me. It is Joseph Mbote Karwenji and Leonard Jao Mutura. It's a ruling on an injunction. What has intrigued me is that it is 29 pages long.
Yes.
29 pages, well written, cited authorities, gone through the arguments of all the parties. It is well written. My concern is, as a judge, would you have the luxury of writing 21 pages for every application for injunction?
Honorable Judge, even as a magistrate, I don't. But if you look at the introductory part of that ruling, I later came to learn that the advocate for the plaintiff was a newly admitted student. And so his pleadings were so convoluted that it was not possible. Like I said, he had mixed everything up. Why that ruling was long, in fact, I usually do 5 or 6 rulings and judgments every week. That one, I put just that one. Because I first of all had to organize the pleadings to ensure that the ends of justice are met. Because notwithstanding the fact that he was not able to succinctly and precisely express himself, he also deserved fairness. That one is particularly long because I first of all had to even rearrange his prayers. And thereafter, his affidavits were all mixed up.